This information is for victims of domestic violence. This will help you decide whether you need an order for protection and explains how to get one. There are 3 ways you can get court protection. You can get an order for protection, a no-contact order, or a restraining order.
What is a protection order?
An order for protection is an official court order. It can order your abuser to stop being violent and to stop threatening, harassing, or molesting you. The sheriff will be notified of your order for protection. If your abuser violates the order by attacking, threatening, harassing, or molesting you, the sheriff's office has the responsibility to enforce your order and arrest your abuser. The order can also protect and give you temporary custody of your children, order your abuser out of your home, and/or order him or her to get counseling.
Do I need to get a court order to get the sheriff to help me?
Not necessarily. The sheriff can arrest your abuser, even if you do not have a court order, if your abuser is either your spouse, former spouse, someone you live with now, or someone you used to live with, and the sheriff has reason to believe your abuser assaulted you within the last 4 hours. If you are attacked, you should call the sheriff immediately. Even if your abuser is not arrested, you can file criminal charges against him or her by contacting the prosecuting attorney's office.
Can I get a court order protecting me if criminal charges are filed against my abuser?
Yes, you can get an order called a no-contact order.
What is a no-contact order?
Through a no-contact order, your abuser is ordered to stay away from you and to stop assaulting, harassing, or threatening you. If your abuser violates a no-contact order, the sheriff has the responsibility to enforce your order and arrest your abuser.
What is a restraining order?
You can only get a restraining order through a divorce, legal separation, or custody action filed in Superior Court. It is more complicated to get a restraining order, and you may need a lawyer to get one. The sheriff has the responsibility of enforcing restraining orders.
How much will it cost?
There may be a filing fee to start your action. If you do not have the money to pay the filing fee, the court can allow you to go ahead without paying. There may be a charge for having your papers delivered to, served on your abuser. The judge can order your abuser to repay you for any costs and expenses in your case.
Who can get an order for protection?
You can get an order for protection if you are a victim of domestic violence. The law says you are a victim of domestic violence if one of your family or household members has tried to physically hurt you or has actually hurt you, threatened you with immediate and serious harm, and/or sexually abused or raped you.
Who can I get protection from?
An order for protection will protect you from someone you are married to, someone you used to be married to, adult in-laws and relatives, someone you have had a child with, someone you live with, or someone you used to live with.
How long will it take to get an order for protection?
If you are in an emergency situation, you can get a temporary protection order the same day or the day after you file the papers with the court. You can get a temporary protection order right away if you think you or your children could be seriously harmed by your abuser. A temporary order will last 14 days, but can be renewed. You have to go to a court hearing before you can get a full order for protection. A full order lasts up to 1 year. The court will notify you in writing of your hearing date. The date should be within 2 weeks. You must show up in court on your hearing date, or you will not get an order for protection. At your hearing, the judge may do one of the following. If your abuser was given your papers at least 5 days before the hearing, the judge can give you a full order for protection. Or, if your abuser did not get enough advance notice, the judge can give you a temporary order that will last another 14 days.
Can my abuser stop me from getting a protection order?
If your abuser wants to contest your petition for an order for protection, he or she must come to the court hearing. At the hearing, you will both be able to tell the judge what you want, and the judge will decide what the order should say. If your abuser is arguing about custody of your children or has hired a lawyer, you should consider hiring a lawyer yourself.
What should I do if my abuser violates the protection order?
Call your law enforcement agency. Tell them that you have an order for protection and that your abuser may have violated the order. They can investigate and arrest your abuser if they have reason to believe that the order has been violated. If your abuser is arrested, he or she could be released. You may want to consult a local crisis service or a battered women's shelter if you think you need a safe place to stay. If your abuser is not arrested, you can ask the prosecuting attorney in the city or county where you got your order to help you enforce it.
Can I change or terminate my order for protection?
You can file the form to change or terminate your order. These forms are available from the court clerk where you got your order. A hearing will be held before a judge to determine whether the order should be changed or terminated. The sheriff will be notified if your order is terminated or changed. If you would like to read the state law itself, it can be found in the Revised Code of Washington at section 16.09.050, 26.50.010, and 10.31.100. This can be found in your public library. Notice, if you are the victim of domestic violence, and if the offender is arrested, a complaint will be filed which commences prosecution. Please contact the Okanogan County Prosecuting Attorney's Office at area code 509-422-7280 regarding prosecution of this complaint as soon as possible. You also have the right to file a petition in Superior or District Court requesting an order for protection from domestic abuse that could include any of the following: an order restraining your abuser from further acts of abuse, an order directing your abuser to leave your household, an order preventing your abuser from entering your residence, school, business, or place of employment, an order awarding you or the other parent custody of or visitation with your minor children, and an order restraining your abuser from molesting or interfering with minor children in your custody. The forms that you need to obtain a protection order are available at District or Superior Court. Information about shelters and alternatives to domestic violence is available from a statewide 24-hour toll-free hotline at 1-800-562-6025. The following resources are also available: the Support Center at area code 509-826-3221, the Victim Witness Assistance Program at area code 509-422-7280, or the Okanogan County Sheriff's Office at area code 509-422-7232, or at 1-800-572-6604. This has been presented by the Okanogan County Sheriff's Office, located at 123 5th Avenue North, Room 200, Okanogan, Washington, 98840.